I would like to thank everyone today for joining us at this OxFirst webinar on navigating your IP business strategy through turbulent times. Thank you so much for taking the time for joining us today. I'm super happy that Professor Ian Harvey has offered to present today and to share his views and perspectives on what current times in a struggle between COVID, a dispute between China and the United States, can mean for IP business strategy, and generally speaking, what we can do to enhance IP as a business and the management aspects of intellectual property. So for those who don't know OxFirst is a consultancy firm which is specialized on IP management and economic aspects of IP. We have a keen interest on assessing the value of IP, helping companies enhance their business strategy through IP, and assessing potential economic effects of certain moves in the IP space, be it on patents, copyrights, or trademarks. And we have been now up for 10 years. It's our 10th anniversary coming up in a couple of months, and our webinars are happening once a month ideally. And and with that short background, I should maybe just say I'm really feel privileged that Ian has agreed to talk. Ian has achieved an awful lot in his life. He has been one of the key people, I think, who has helped the UK formulate its IP strategy. He has been very active in China in the IP space. He has worked for the World Bank. He has been the managing director of a patent strategy company, BTG, for many years, and has made the turnaround there. He's a graduate from Harvard and from Cambridge. He doesn't have Oxford on his resume. That's maybe a shortcoming, but otherwise I don't see any flaws. I'll let you now share your screen.
Great. Okay, well, thank you very much, Roya. And good morning, good afternoon, whatever time of day it is in your zone. My overall message and my starting point is that IP today should be one of the key planks of a company's corporate strategy. And yet, for still the majority of firms, too often it is not. And I see that the response of companies to China and to COVID actually identifies those which are doing well and those which are doing less well. Too often, IP is seen as something legal and complex, which has to be done properly, rather like making sure that your title to a building is properly researched and executed. But there's no need to get into the details or the complexities of it. And I think there are two reasons for this. That first, managers don't understand IP, and therefore they haven't learned the right questions to ask. And on the other hand, IP professionals themselves are not very good at simplifying the complex legal details so that mere mortals can understand the fundamental issues which are at stake. And that is because I see that in large companies, too often the IP people are a cost center buried somewhere south of the legal department and have little connection with the strategy of the real business. And on the other hand, in small companies, managing an IP is seen as a cost minimization exercise, and so is often outsourced to technical and professional people who don't know or understand the business itself. And my view is that the principles of the various forms of IP are actually quite simple, but too often not understood. And there are often multiple ways that IP can be used, and those different ways can imply completely different strategies for creating or using the IP. And then what is happening with COVID and how companies handle or fail to handle the challenges of COVID with IP in China, those reinforce the centrality of IP to business strategy and its global nature. Now, I've arrived at these views based on the experiences, Roya has touched on a few, which I had during the sort of 4 distinct stages of my career. And if you'll forgive me and let me step back and run quickly through where I have been and maybe what I've learned, so you can calibrate where I'm coming from. I'm actually not a proper professor that Roya has billed me as. I'm a business person with a technical background. My first phase 1, was mechanical sciences from Cambridge. And after that, I was involved in down sluice gate design in Canada, and then a tiny little bit of work on the Concorde supersonic aircraft. I then left Vickers and joined LaPorte Industries, a chemicals firm, now part of Tronox. I was involved in TiO2 plants, which is a pigment designing, building, redesigning, repairing plant. Then I went to Harvard in phase 2, got my MBA there, and for the next 7 years, lived in Washington, DC, working for the World Bank, living in the US, but working in many different countries. So I was involved in agro-industry projects in South Asia, India, Bangladesh, Sri Lanka, Burma, and also in cross-sectoral projects covering transport, energy, agriculture, and so on in the former French-speaking West Africa, mainly Guinea and Senegal. Working for the World Bank made me aware of the huge differences in cultures and attitudes, political or business, be it between, say, different Asian countries, or even just between the US and Europe. And it's very hard to find one size which fits all. And I'll come back to culture when I talk about China and IP. So after 3 years traveling with wife and young family, phase 3 was with BTG, technology transfer, which is where I began to learn about IP itself. And then phase 4, which is the one I'm currently in, so-called retirement, which I'll come back to later. Now, as chief executive of BTG in 1985, that's where I began to learn about IP. Initially, BTG was government-owned. It was patenting and licensing all the inventions made by UK university and government research labs. And BTG itself was actually more about patents and copyright, trademarks, and designs, but I'll come a bit more onto those later. BTG itself was created in the late 1940s with a right of first refusal to develop, patent, and commercialize all inventions from publicly funded research. And its business was funding innovation, developing, creating, commercializing the resulting IP. And we actually developed an unmatched global capability to do all of that. It had one of the largest IP departments in the UK, between 30 and 40 patent agents, scientists, lawyers, and negotiators. And what I learned from BTG's 50-year history and major innovation is still true today for most sectors. BTG had many major inventions and technologies, and this arrow gives you a quick overview of what we did. And I'll touch on just a few of them. It funded the first digital computers in the UK, created patent pools around them to kickstart the UK computer industry. Then the first really major technology were the cephalosporins, which had over half the world's antibiotic market. And that enabled BTG to become profitable after 20 years. Then moving on to the synthetic pyrethroids, the second major technology we had, which had about a third of the global insecticide market. And it's a very interesting story because you can learn quite a lot about innovation and IP from it. The first invention made was permethrin, invented in 1972 by Michael Elliott at Rothamsted, and BTG patented it. We then licensed Sumitomo, who then invented another pyrethroid, which is called fenvalerate. Then Elliott actually was reading the patent applications by Sumitomo and realized that Sumitomo was taking the science in an area which he hadn't thought about. And based on that, he then continued his research at Rothamsted and developed two more pyrethroids, cypermethrin and deltamethrin, again patented and commercialized by BTG. And there's some interesting data because BTG had 5 patents, of which 3 were commercially successful, but there were over 50 patents globally. Most of those were Sumitomo, but only one of theirs reached the marketplace. And yet its patent filings, those 40 or 45, they illuminated and stimulated the next and very successful inventions in a completely different continent. And that's exactly what the patent system is intended for. Whether it's in business or academia, you should be also reading relevant patent applications, because that's telling you where the science is going, not through just science papers, but also through the patent system. It also demonstrates how few inventions and patents are actually successful. In this case, 4 out of 50. In general, our view was that 95% of patents have no commercial value. And I'll come back to that later. Then there was the next major invention was MRI, invented by the late Peter Mansfield, later Sir Peter and a Nobel Prize winner. And there are some important lessons, I think, about innovation, where it comes from, and IP, to be drawn from MRI. The story is that Peter was not a great student. He actually dropped out of school at 15 because he was told that science wasn't for him. He became a printer's assistant. And after national service, he studied for A-levels at night school and eventually got a BSc in 1959 at Queen Mary in Westfield, and then got a PhD in 1962. And in 1964, he went as a lecturer to Nottingham University, where he started research on what became MRI. But his professor at the time told him it was going nowhere and he should stop his research. Peter came to BTG, and we, together with the Medical Research Council, the MRC, continued to fund his work. And he made some interesting inventions. And BTG folklore has it that his BTG patent agent said, Peter, look, if you can do X, then surely you can do Y as well. And Y would be very interesting. And Y was slice selection, which Peter went on and created. It's one of the main foundations of MRI. And the first 2 lessons I learned from MRI is that there's a real distinction between the output of high quality research and making important inventions. Important inventions can come from anywhere, not just from the obvious stars in the great research centers. Increasingly, some will come from China. And patent attorneys are an active part of creating inventions, in my view. They certainly can be. So they should be actively engaged, not just creating something which is legally solid, but understanding the marketplace through an IP lens, where it's heading, what it needs, and so to be an active participant in defining the nature of an invention. Now, it also brought together other MRI inventions from Oxford and Aberdeen, and we created a patent portfolio. We then approached the imaging industry, EMI, which had developed the CAT scanner, GE, Philips, and so on, and found that actually no one in the current scanner business thought that MRI was a potential business. So we licensed 4 newcomers who found the package of patents very attractive. They were Asahi, Shimadzu, Pika, and a startup in Aberdeen. And in Aberdeen, you had John Mallard, who was, again, he was told, don't know why you're bothering, it'll never work. He invented MRI spin warp, and he made the first full body scanner. He actually died last week, in fact. But his startup failed, as about 90% of science startups do. Now, Asahi and Shimadzu led the industry. Pika was acquired by GE. The rest of the industry then woke up, realized their earlier mistake, and started to develop and sell MRI equipment. And the whole industry eventually was licensed by BTG. So several more lessons which I learned. Commercially important inventions and products rarely depend on a single invention. Even today in pharma, just look at the way the pharma industry has brought together ideas, patented inventions, and products globally from both inside and outside the sector to produce viable COVID vaccines in under 12 months. And I'll come back to the impact of COVID on pharma later. Next thing I learned, similar inventions or complementary inventions are quite often made at about the same time. And it can be helpful and time-saving if they can be brought together, as we did with MRI. And if you have a good package, that'll often enable companies to commit resources to the high-risk investment in completely new areas. And that, again, is what the IP system is intended for. And the IP professionals, coming back to them, need to be aware of the opportunities to bring technologies into the same portfolio. So, for example, if you're working for a company, there may be a choice between filing a weaker patent with broad claims or a stronger patent with narrow claims. But if you file a patent with narrow claims, you might choose to do that in the knowledge that you can work with or acquire or license related, competing, or complementary patents. So these are major strategic questions with large cost implications. The next thing I learned was that companies are very often not interested in taking up new technologies if they threaten their current products. In the present, just think about the oil industry and its reluctance to embrace new carbon neutral technologies. Now, some are slowly beginning to change, but with quite different strategies. BP to renewables, Shell to electricity, Exxon is doubling down on oil. So often you need, if you have a new invention, you need to look outside the current players that are operating in that marketplace. Next point, most science-based startups fail. About 10% succeed. If you're a university, you should not think that startups are the only way to go. I regard MIT as being the gold standard for commercializing IP. They do 10 licenses to existing companies for every startup which is created. And lastly, if you have a patent, provided you have a decent legal system, you have the power to force people either to stop infringing or to take a license. And I'll come back to that, talking about China. Now, BTG had many other health-related inventions, both in pharma and medical devices. One, Zytiga abiraterone acetate, is a treatment for prostate cancer. It, in fact, is in the headlines right at the moment because NICE, contrary to most other countries, hasn't approved it yet. The revenues from that are $3.5 billion a year. There's Lemtrada, Campath 1H, the first humanized monoclonal antibody to be approved for human therapeutic use. Revenues still around $350 million a year. We had the first disposable contact lenses, the first widely available artificial hips. And there were also many non-medical products, ranging from Christopher Cockerell's hovercraft to David Payne's erbium-doped optical amplifier, which enables some subsea long-haul optical cables and therefore the internet. So moving on to what I was talking about earlier, which was the awareness of IEP. After I'd been at BTG a few years, I started to meet the chief executives and corporate board members, both as licensees, but also through conferences like the World Economic Forum. And I thought that these people would be on top of the IP on which their companies were largely based. How wrong I was. Many didn't even know what a patent actually did and couldn't describe it to me. Sometimes not even the difference between patents, copyright, trademarks, and designs, or what the legal differences made in practice. Consequently, they saw IP simply as a legal and complex right handled by a specialist deep down in the legal department. They didn't really understand the competitive IP environment in which they lived, and therefore they couldn't explore different IP strategies involving potentially quite different corporate strategies for operating in that often complex environment. And I'll come back to that with COVID vaccine strategies. So for examples, thinking about the IP environment of your business or sector, how do you plan to use it? Do you plow your own furrow, not worry about anyone else? Do you in-license? Do you cross-license? Do you try and create a patent pool? Do you acquire a company for its IP? Do you study your competitors? One example I have is where Air Liquide found one of its major product lines by continuously monitoring the patent applications of its competitors and discovered that there was a line of science which they hadn't even thought about and enabled them to go down a route which they previously thought was closed to them. Do you sell non-core IP? As Marshall Phelps, then head of IP for IBM, did in 1994. From a standing start, in 12 months, he started to generate $1.5 billion a year, which saved IBM from bankruptcy in 1994 or 1995. But they could have done that many years earlier and added that to the bottom line. But no one in the board thought of reaching down to say, what can we do with our non-core IP? And then, of course, where do you put your R&D dollars and why? Each of these different areas has got major differences in costs, in potential risks, in potential upsides, and in time scale. And therefore, they should be absolutely fundamental to the strategy of a company. but so far they are not. Now, why is this? Because the other side of the coin of management blindness to IP is the issue with IP professionals. Many of them, I think, find it very hard, very difficult to engage in the way that I've talked about, because theirs is a legal process where you really have to be meticulous in the detail rather than having a broad view of the world. And they usually find it very difficult to talk about IP choices in simple terms by removing the complexity, which are often not relevant to strategic choices, so that they can reduce the issues to one which the layperson can understand and talk about. And along those lines, I found that at BTG, only 4 or 5 of the 30+ patent agents we had could themselves really think in these very broad strategic terms. And actually, they were probably not the best people to draft very good patent claims, because they were detailed people, and you need to be able to put a wet towel around your head for a week with all the prior art around you thinking, how do you exactly draft this? So you need to find people who have both the understanding of the IP and the ability to articulate it to the senior management of a company. Also, coming on to some of the things I learned at BTG, the use and value of IP can vary a lot by sector. And obviously in the pharma and biotech sector, patents are absolutely essential because they underpin what we know are often very large and high risk future investments, not just in development, but also, as we've seen with COVID, also in clinical trials. This investment is usually in the hundreds of millions and sometimes in the billions of dollars. But at the other extreme for pharma, you have perhaps the high-tech sector. And this is often a very fast-moving and complex one where your smartphone, for example, embodies perhaps 250,000 patents, and where there will be a small number of fundamental and hopefully protectable advances, many incremental advances which may or may not be worth protecting, and then a myriad of small ones which are probably not. So you need to be very clear-eyed about whether you could make money out of just one of those 250,000 patents, and then think very hard and rationally about what you have, whether it's worth protecting, and thus what value it has either to you or to someone else. So IP can have great value to a business. It can also have zero value to a business. But unless you ask the question, what is the value of my IP? You won't get the right kind of answers. You will not know whether you're doing the right thing or missing things to create value or just wasting your money. Now, after I retired from BTG, I moved on to phase 4 of my life, and I tried to get business schools interested in including IP in their curricula. Because I saw that at Harvard, for example, I was taught about accounting, not because I was going to become an accountant, but because you have to understand finance if you're going to be chief executive of something. And I regard IP today in exactly the same way. Unless you have the basics of understanding of IP in its various forms, I don't think you're able to lead a business where the probability is most of its value will lie in its intangible assets. When I went to Harvard, they said, oh, if people want to learn about IP, they can audit IP 101 across the river in the law school. Ridiculous. They didn't know they didn't know. They didn't know they didn't understand. So I've had great lack of success in getting business schools interested in teaching IP. Imperial College, where I am an adjunct professor now, has had some interest. But I started going to China regularly after I retired in 2004, running courses on IP and innovation funded by the UK and Chinese governments. And then I found that Tsinghua University in Beijing was very receptive to a business school course on innovation. Innovation, IP, and business strategy. And I ran that course for almost 10 years. I also spent a lot of time with Chinese academics, business people, and quite a few government officials and ministers. I've met a lot of ministers in my time with the World Bank and then BTG. And of the Chinese ministers and other people, most are very impressive, both technically and in managerial terms. And I'll come back to that in China. So moving on to COVID, which is, I think, highlighted many of the issues for those who look. Taking patents in the pharma industry first, If I look back 30 years ago, the pharma industry made a real hash of providing HIV drugs to South Africa for the treatment of AIDS. And they created a very strong negative image for the industry. The industry actually was hauled back to the table through the Doha Declaration in 2001. Because although the industry should have been able to come up with what was contained in the Doha Declaration by itself, my experience of it that time, meeting the chief executives, was that the management just did not understand IP, not just well enough, but at all, so they could take the initiative and cut through the issue of patent rights and access to life-saving drugs for LDCs. COVID and vaccines, I think, shows how that has changed in the pharma sector, because there's been an unprecedented collaboration between many different companies, some competitors, even though a lot of IP underlies the technologies which are being developed and used. And I can see that the greatly improved understanding in the pharma companies, understanding of how IP is integrated into their business, has enabled a much greater level of cooperation, but with very different strategies between the different firms, both epidemic, post-epidemic, and globally as well, including for the developing world. For example, AstraZeneca has chosen a very different commercial path, initially non-profit, compared with the one from Pfizer-BioNTech, which is profit-based. Both companies have taken the moral high ground, which the industry failed to do in South Africa. They've both taken the moral high ground and understood the public interest need to create a vaccine in the shortest possible time. Both have made their IP available, but under quite different commercial terms. They haven't given it away long-term, but been very open about their strategies, both of which are probably viable long-term strategies, even though they're different. Time will tell. But COVID vaccines have not been an IP-free zone, but one where the companies have made their IP available for short-term needs, but without compromising the long-term interests of remaining viable in the medium to long term. And making decisions like this really does need a good understanding of IP at the highest levels. I know Pascal Soriot, the CEO for AstraZeneca from his Roche and Genentech days, and he is someone who really does understand IP very well. He can also articulate it to the layperson. I don't know Albert Bourla, the CEO of Pfizer, but having looked at his CV, I'm sure he's been at the coalface in IP and understands it well, judging by how Pfizer have approached how they've approached COVID. I'm sure that the decisions they've taken will have been discussed by their boards in good knowledge of the implications for the different strategies. So I now see that the pharma industry has really understood and is integrated much better into their corporate strategies. Now, turning to trademarks and the shift from tangible to intangible assets. Arcadia was a well-known retailer with many different stores and brands in the UK, the EU, and I think outside as well. Brands like Burton's, Debenhams, City Chic, Evans, Miss Selfridge, and so on. And you may know that it had to go into liquidation recently as a result of both failing to compete in the online as well as physical stores, and then sealed by the problems brought on by COVID. And you can look at the resulting value from its bankruptcy. 90% of the remaining value is in the intangible assets. The IP of the trademarks has been purchased for about £350 million, compared with 0 for its physical stores and about 65 for some usable stock. So the value of these brands, the intangibles, has been highlighted by COVID. Now, turning to the auto sector, I see that this is in ferment brought about by climate change needs. The shift to possibly self-driving electric cars and many new technologies, not just batteries, but AI, sensors, LiDAR, radar, GPS, a huge amount of IP is being created and litigated, as we've recently seen with the attempted theft of Google's tightly held self-driving trade secrets IP by Uber. Contrast that IP strategy with Tesla's semi-open source approach to its patents. Maybe this will be like smartphones and the 250,000 patents which they embody. And who knows where the breakthroughs are going to take place with electric cars, because as we all know, batteries as they are still heavy and actually CO2 intensive in making them. Where will they come from? For example, I was talking a few days ago with a mathematician and physicist who I've been helping a bit, and she is at the leading edge of relativistic quantum information and entanglement theories, and who believes that it should be possible to replace GPS and all those thousands, tens of thousands of satellites now, to replace GPS through the interrogation of magnetic and gravitational fields. And she's filed patents on it. So there are many new companies in the auto field. We don't know which ones are going to be successful, where the IP is going to come from, but clearly IP is going to be very important. Who knows who owns what, who needs what, who will get access to what are going to be key questions for the auto industry in the next decade. And those who win are going to be those who play the IP game as well as the other things of strategy well. So the auto sector is really a segue finally into China, because China is currently a leading player in key electric car technologies. And before long, China is going to be the world's largest economy. And it has, behind that, a 2,000-year history during which, much of it, it was the most creative country, certainly until it closed up in the early 1400s. And one sees that old inventive habits and cultures die hard. China today is a creative and industrious country. Today, it is becoming that again. There's a very interesting book by Kai-Fu Lee, AI Superpowers, who was brought up in the United States, worked in Silicon Valley for quite a long time, then moved to China where he's a venture capitalist. But he gives a very good overview of how China and the United States compare, not just in innovation, but the speed of innovation and the nature of it. Both have their places, but they're completely different from each other. And I think understanding that, again, is one of the cultural differences which companies need to understand when they're thinking about IP. If we look at China, it now files as many patents domestically as the next 5 countries combined, of which the US is one. China last year also became the largest filer of PCTs. And don't tell me, well, they're valueless patents because they come from China and the research there isn't very good. In most countries, only about 5% of patents have any real commercial value. And if it's only, say, half that number for China, or even a quarter, it's still a very large number. China is already at the leading edge of quite a few sectors in the high-tech area, as well as others. For example, in fintech, it's leading in 4 out of 5 categories, according to KMG, which was, I think, came out in the FT a little while ago. And very importantly, contrary to much of what you hear, it also has an IP system, which is now good by global standards. And it's actually better in most respects than the US. It's faster, it's cheaper, it's generally better quality, more consistent decisions coming out, and it's less biased against foreigners. Over 90% of foreigners win their cases in the court of first instance, reduces to just over 85% on appeal in the final IP tribunal of the Supreme Court. Compare that with the United States. Between 35% of foreign companies win in the court of first instance, 50% on appeal. There's more litigation in China than in any other country. 98% of the cases are Chinese suing Chinese, which indicates to me, suggests to me, that the Chinese think that the IP system is worth using, the IP court system is worth using. And if you don't believe all this, go to my website, it'll be at the end of this, and you'll find a briefing paper about IP in China, myths and reality. It's based on facts, not guesswork or assumptions from an ignorant distance. China is going to be one of, if not the major player in many new technologies. We mustn't try and ignore it or try to sideline it. It has its own market of 1.4 billion people plus neighboring Asian countries. And that means that it can establish its own technologies and standards, and we will suffer if we do not participate in that. We also need to be careful about the assertions of IP theft. Some of it may be government. Some may be corporations doing what other corporations around the world have done, like Uber and Google. But I do know that much has been as a result of companies not understanding the Chinese IP system, which is quite different from that in the US or the UK, and they make major avoidable mistakes. Companies which have understood China very well and flourished: Microsoft, P&G, Philips. As we've also seen, collaboration as well as competition is often essential to generate rapid technical progress, as we've seen with COVID. Climate change is an obvious area where we need radical new solutions. And if we try and ignore China or sideline China, these changes will happen more slowly than they otherwise would. They will still happen, but they could well be dominated by China. And we may not like what China is doing in Xinjiang or in Hong Kong, but we will all be losers, I believe, if we cannot find ways of collaborating with China in the technical area. So you must file your patents in China. And it horrifies me when I hear business people say, we mustn't file patents in China because we don't want to have our technology stolen. It probably doesn't need saying to you, this audience, but just in case, you have publicly disclosed your invention in getting a patent. Filing a patent in China gives nothing more away. The Chinese can, and they will, read your foreign application and be legally free to develop, use, and improve that invention anywhere that you do not have a patent, including, of course, China. Be in no doubt, you can enforce your patent in China. But some companies, including major companies, still do not take China seriously. I point the finger at the UK in this. The UK is particularly bad at filing its patents in China. Some, including major companies, still do not take IP seriously. So I should have given you the previous one. Okay. And I have one slide which shows just how widely company practices in China can differ. You can see here, the UK company on the left is actually Rolls-Royce. And this is comparing aero engine patents by Rolls-Royce on the left, GE in the center, Pratt & Whitney on the right-hand side. And you can see that Rolls-Royce only files 4% of its patents in China, compared with 23% of GE, 16% by Pratt & Whitney. Rolls-Royce has 2 joint ventures in China. Which company do you think is going to be in the stronger position if there's patent infringement or if there are negotiations about the terms of a JV? And I see that with far too many companies. Some companies really have understood how China operates, and they do file patents in China, but an alarming number of countries still do not file in China. So how you use your patents in China is a key strategic issue for the CEO and the board of the company. The issues are technical, economic, market, and presentational as well. All are very important, but there are major choices to be made about China. Do you ignore it? Do you license into China? Do you sell into China, manufacture in China, set up shop in China, have a joint venture with a Chinese company? Do you do any R&D in China where there is a huge research base? What are your objectives and what are the risks and benefits of possible scenarios, having IP as a key element of that? Now, finally, like Henry Kissinger, I'm a believer in engagement with China for 3 reasons, all self-interested. If we're going to succeed in defeating climate change, we need the best of technologies in the shortest possible time. Some of these will and already are coming from China. They will come faster if we can work together. If we're to succeed economically and competitive as countries and firms, we must not cut ourselves off from the value of the Chinese market, as well as the technologies which will emerge from it. And thirdly, if we're going to influence China in political areas, I believe very strongly that engagement with care is better than war, be it economic or physical. So let me say it again. Unless you have IP in China, you will have nothing in the world's soon to be largest economy. And the paper that I mentioned about IP in China is right here. So thank you very much. Back to you, Roya.
Thank you, Ian. Thank you, Ian. That was really, really interesting. Ian, can you talk, you mentioned an open source IP strategy. What is that? Can you talk about that? What is meant by an open source IP strategy?
Well, in the
Is
case
that not contradiction itself?
Well, in the case of Tesla, they have said that any company will be free to use its patents. But in the case of Tesla, they said if they operate in a certain way, if they don't assert their patents against Tesla. So Tesla has patents. Any company is free to use them in their own cars, in their own batteries. But those companies, in return for that, must also agree not to sue Tesla under the patents which they have created. So that is one form of open source. But that's different from a patent pool where companies or individuals will put patents into a pool on pre-agreed terms, perhaps for the percentage of revenue sharing or the license terms which each of them will use.
So that, I think, okay. And then also, because we're talking Tesla, you know, Nikolai Tesla had the same destiny as Mr. Mansfield. He studied in Graz, in my hometown, actually.
Right.
And he was kicked out of the university because he had these utterly crazy ideas about alternate current. And at the time, the professors in the University of Graz said, look, Mr. Tesla, these are the wrong thoughts. Out you are. And so he was a university dropout. And only in the United States, he had a chance, but he screwed up his own IP strategy. I mean, his way of negotiating his licenses was a disaster.
Yes, but then
Total disaster.
Yes, but then he was supported by a major US industrialist, and then alternating current got into a battle with Edison's direct current. And direct current is very inefficiently transferred at low voltages. And in New York City, for example, you have to have a power station every half mile or so because of the losses if you transmitted it at 110 volts DC. But then when the competition came up between AC and DC, AC being at 240 volts, Edison characterized it as the voltage of death, the current of death, the electricity of death. And there were really lots of dirty tricks. So playing fast and loose with IP and the story around IP isn't new. Edison did it and Edison lost. He lost at the World's Fair because they had a competition for lighting the World's Fair in about 1892, and Westinghouse, who had by then acquired Tesla's patents, won the competition with a bid of about a third that of Edison. So Tesla won.
There are some questions. At least I see one. Okay, from Paul Fuel. He says China, there's another question. Okay, so China starting developing a major IP ecosystem prior to the accessions of Xi Jinping. Certainly prior to 2013, the aversion to China represents a form of xenophobia, but I'm curious whether the changed political landscape, both with the accession of the new president of Jinping and the later situation with Trump, is reflected in the data that you consider. For example, do you think has the proportion of foreign firms succeeding in action decreased compared to, say, 2009?
I don't have the very latest data, but I have in the websites which I follow, there's been a decrease in the number of patents filed by China, as it has been in a number of other countries, but I haven't seen any sign that the legal system is differentiating against foreign firms. Clearly, The policy of the current government may make it harder for foreign firms. But those who want to operate in China, I think, can still do so. For example, one of the issues has been that a number of companies assert that the only way you can set up in China is through a joint venture. Well, there is one law which says you have to have a joint venture if you're going to set up in China, but there's another law which says actually there is a way around that. So you need to have a good lawyer who understands Chinese law extremely well to be able to take you through this kind of not a fog of war, but China is complicated and you need to have people who can work their way through it. But provided you can, the Chinese legal system will work extremely well. For example, just a couple of the differences. China has a statute law system, not a common law system. So the method of getting evidence is quite different. Many Americans say you can't have your day in court, you can't gather evidence. Well, that's just like Germany or France or any EU country which operates under statute law, civil law.
That was German influence, by the way. That is not a coincidence.
It's not a coincidence because it was technical assistance from the German Justice Ministry that had a major part in setting up the IP legal system in China, starting in 1984. And actually, intellectual property, patents, were one of the first things that you could legally own in China. You still can't own a building. You can have a 99-year lease on it, but you own your patent. So from 1984, they've had a series of 5-year plans, of which IP is a key part. Each of those plans has got about 20, each of the IP strategies, 5-year strategies, has got about 20 component parts. For example, one of which is the education of children. Children start being taught about IP from the age of 5. I've got the books here, the comic books for the 7-year-old, teaching them about patents and copyright. So by the time a child is 10 or 11-year-old, they can probably give you a pretty good view of what a patent does, copyright, trademarks, and so on. And they're really bringing up a generation which thinks that IP is central to an economy. And yes, 1,500 years ago, copying was the way you paid homage to the master. You copied what they had drawn, you copied what they had painted or made. So that was part of the Chinese culture, what I was talking about right at the beginning. They had to turn that on its head from copying is something which is important, which is the right thing to do, to copying a patent or a trademark or a design is wrong. And one of the phrases they used is stealing intellectual property is like stealing someone's mind, because that's come out of your mind and you mustn't steal people's minds. And they really did turn 180 degrees in terms of changing people's attitude towards the way IP is used, owned, licensed, and sold, and so on.
Ian, you mentioned that the board needs to know about IP. What do they need to know exactly? What do they need to know patent law? And what is it that they really, why should they care? A board member has 10,000 things on their mind. Why IP, and what do they need to know about IP?
If you're talking about a major product, the board needs to have some broad concept of what you can do with the IP if it's based on IP. And I can, just to give you one example from a small firm, I was asked by a venture capital company, to go and have a look at a company which they'd invested in. And I went to see the venture capital company because I knew the chairman, and they called itself IP centric, but there was no one on their board and no one that I really saw in the investing side that had any background in IP. And they said, Ian, you don't know what you're talking about. Go and have a look at this company, which has got some very good IP. So I went up to the company and I asked about their patent, and they showed me what their patent was, and it was a process patent. And I asked them what their commercial strategy was. And they said, well, we're selling the equipment and we're going to make our money from the product which has to be used inside the equipment. And I said, you have a patent on that component which is going to be used? And they said, no. And then it was the marketing director who then looked at me and said, you don't need to ask the next question. Because they were selling the equipment which embodied the process. They were hoping to make their money from a non-patented product. And of course, anyone could buy that product from anywhere because they bought the equipment, then they had no business. Because they bought the equipment, then they were free to use the product itself. And the result was the company had to change its business model entirely, raise another 50 million pounds, because what they had to do then was to build the equipment and lease it. And as part of the lease, they provided the consumable product on which they would make money. But that cost them a year and another 50 million pounds. And the board had never asked the question, what does this patent do for us? And I think that is typical. If I think of the pharma industry, then the pharma industry needs to know broadly what our patents are, in which countries do we have patents, are they in the least developed countries, how are we going to collaborate? And so you need to have a general picture of what the IP landscape is, so you can make some judgments against all the other issues which are part of the strategic decision which boards have to endorse, which is put forward by the CEO and management team.
Get a bunch of other questions also. Well, okay, David Melville, what do you think the UK government should do to ensure greater understanding of the value and importance of IP? And in particular, how can we improve collaboration between publicly funded academics and the commercial world? Secure the public interest in the product of those collaborations.
I think that the UK has been doing well with its catapults. And the catapults are set up to promote developments in particular technical areas and market areas. And I would say in those, you just reinforce the importance of IP. I would like to see IP taught more than it is. It is a specialized course at the moment. I'd like to see the government encouraging business schools, technical departments to teach IP as a general part of the course. Now, the government can't mandate it, but I'm on the board for the Centre of Intellectual Property, which is part of the the Norwegian Technical University and Göteborg University in Chalmers. The Norwegian Technical University is now requiring IP, a short IP course, to be taken for all its students, for all its undergraduates. So when they graduate, they will have some basic concept of what a patent is all about, how it's used. I've been teaching a course to the new young fellows of the Royal Society every year. And it's a 4-day course, and I'm asked to talk for 2 or 3 hours about IP. The first question I ask is, how many of you want to make a contribution to humankind through your research? 30 hands go up. Then I say, how many of you think that intellectual property could help you make a contribution to humankind through your research? And usually not a single hand goes up, except for last year when one Chinese hand went up. And then at the end of the 2 or 3 hours, I asked the same question, how many of you think that IP can help you make a contribution to humankind? And usually 2/3 or 3/4 of the researchers put their hands up and said, we just had no idea how IP worked and what it did and what it did not do. So as I said right at the very beginning, the principles of IP, a patent, are actually very simple. You can make it as complicated as you want, particularly in the United States. It can be complex. There are some complex legal issues, but the fundamentals, I think, are actually pretty simple. And if you can get those principles across to business people, to students, if I can encourage the UK government to encourage the universities to include IP as part of their course, a component, I think it would be money well spent.
There are a couple of other questions. Okay, Jonathan Pearl, there's a lack of transparency in the patent licensing world. Do you see the courts becoming more interested in enforcing front rates? Why are you bringing front up, guys? This is a harmless IP strategy course, not about front, okay, but still fine. Do you see the courts becoming more interested in enforcing front rates for essential patents?
I'm actually not sufficiently close to the courts and FRAND to know what you might be referring to. I mean, my experience of this is that when the parties concerned want it to be transparent because that's the way it's going to operate in the industry, then they'll do so. If there's a commercial reason between the contracting parties for wanting to keep it out of the public domain, provided it's not anti-competitive, and that's an issue as well, then I think they're perfectly entitled to keep it out of the public domain. But anti-competitive practice is important, and you need to watch that pretty carefully as well.
Okay, then there's another question from, thank you both, we are loving the data. Okay, thank you, that's really encouraging. We love this type of comments. There's a question from Matt Lawman. It says he's a patent attorney for 30 years, both in-house and in private practice. And in his experiences, universities still don't teach IP to their science and engineering grads and undergrads, let alone business students. Why is this? I recruit undergrads into the profession, and none have been taught it. Moreover, universities do not understand how to manage their IP. They patent cheaply, badly, and then try to sell exit 2.5 years later before the end of the PCT, so as not to incur large costs. Lack of medium long-term strategy is not practical. What can be done? And I must say, Matt, I confirm your observation. I have also recruited quite a few science people, and they have no idea about IP. And if I ask them, have you thought about becoming a patent attorney? They're like, "Bah, I want to work in an investment bank. I want to work at McKinsey. Why the hell would I be a patent attorney? It sounds terribly boring." So the profession is not well branded to British science students in any case. And when I take them under my umbrella, they feel it's a bit more exciting than they really thought it was. And some of them are now giving it a thought of becoming a patent attorney, but compared to the branding of McKinsey, no chance, you know. Even if they may get kicked out of the company after 2 years, not the same perception.
I completely agree with both of you. The branding of IP is not very good. It's also, there's no what I call an elevator pitch for IP. That is, give me 15 seconds and I'll persuade you that IP is important. Give me half an hour or an hour and I'll give you not just the sort of the simplistic analysis, but I can give you the kind of examples which will help people begin to understand what it's all about. And most people don't know they don't know. They don't know that there are questions to ask. They really haven't understood what IP is all about. And I think your comments about universities licensing it, patenting poorly, delaying it, not knowing what they want to patent, not patenting in enough countries, I think that's absolutely right. But it's also not peculiar to the UK. If I look at the US, I think only 20 universities out of 1,000 actually make money from their technology transfer operation. And the other thing is, which I also find interesting, that MIT doesn't have its tech transfer group as a profit center. It regards its tech transfer operation as a way of getting its research output useful and used. It has a number of rules. For example, you can't be an academic in MIT and be part of a spin-out. You have to make a choice. You're an academic or you're a manager. And actually, most academics aren't very good managers. So if you see an academic going out to run their own spin-out, then that's quite a warning sign, because very often they really don't know the first thing about running a business, raising capital, hiring people, getting focused on finance and so on. But it's a real problem with universities, I think, that a lot of them still don't manage their IP well. I look back at BTG when we were managing IP for universities, and I'm sure we were, maybe rightly in some cases, criticized for having missed things or mishandled. But actually, we had the patenting capability, the funding, the lawyers, the negotiating people, the international capability to really take things forward, as we did with the Pyrethroids, with MRI, a whole series of pharmaceutical products. Most universities don't have that. Now, our right of first refusal, I think, rightly was taken away in 1985, finally. But the result is that most universities don't have the resources to fund that operation well. And so they're usually underfunded, with the kind of problems which you've talked about. But as I also said, that's not only in the UK. I think most countries have the same kind of problem. I would just say that in China, there isn't this lack of knowledge about IP. A remarkable number of people understand IP and the role that it takes in bridging the gap from research, innovation to a final product. And I think that's a warning sign. It's a challenge for us, and we need to step up to it, which is why I put these slides up to show how some companies just are not taking China seriously. And then when they look at that and say, whoa, why are these companies doing this and that company doing that, then you can start to explain, and the understanding sometimes dawns, not always.
We have run out of time. Daniel has sent a whole bunch of links, which we'll look at afterwards. I think there's no time left for doing that. Thank you so much for sharing your views, Ian, and thank you all for your exciting questions. I didn't expect that in an online forum we'd be really having a lively discussion. That's great feedback. Yeah, have a lovely afternoon. This was really helpful, Ian. Thank you so much for your time, for preparing this. I think I'll put this up on the internet to make sure we get the word out. Have a lovely afternoon, and thank you very, very much for joining us today.
Thank you very much, Roya.
Bye-bye.
Bye-bye.